Many of you are very familiar with Anita Bromberg. She's a human rights activist. She's the National Director of Legal Affairs for B'nai B'rith. And Anita, please come up and introduce our next two speakers.
Good morning, everyone. I'm going to take this opportunity as co-chair and administrator of some of the details to point out a couple things. Please do make sure to help yourselves to the breakfast and the coffee and the juice that is being replenished as we speak is there for you throughout the morning. Second of all, just an administrative detail came to my attention. You have, for those that need it, the CPD generalized letter is in your binder. If you've had the chance to peruse through the binder, you'll find a generalized CPD credit letter is there. If you want a letter that specifically has your name on it, that's available at the registration desk. Let me also take this quick moment to thank Charles and, of course, his staff, Catherine, Carmen, and others. It's been really my pleasure, privilege to work with you to bring this annual event to fruition, and I'm certainly hoping you're enjoying it and finding it insightful. The next two panelists are perhaps the newcomers to the seminar, but nonetheless very experienced lawyers that I'm sure you'll find fascinating. Their topic, as you'll hear, is fraud, constructive trust, and the Bankruptcy Act. Greg Sidlofsky, he's a partner in the firm Wagner Sidlofsky. He's an expert commercial litigator, certified by the Law Society in that area, and whose practice includes such areas of practice as fiduciary duty, fraud, and of course estate litigation. I was looking through his resume, as you can, and everyone's resume is set out in the bio section of your binder, so you can go through the details there, but I took a moment to look at the impressive list of cases: 3 Supreme Court cases, 20 Courts of Appeal cases, 70, I think I counted, Superior Court cases, and of course the list goes on. I think that the total of that indicates at least one reflection of the expertise that he has as a courtroom litigator. 2 cases I noted: Winter against Royal. Lesson to be learned there is a succession plan and should be in place even when you're dealing with business. And another one, the credit finance case, where his expertise in constructive trust in case of fraud has come through, and it's that expertise that you'll hear about from him this morning. Secondly, we have Brendan Donovan. He's an associate with the firm Wagner Sidlofsky and a member of the firm's estate and commercial litigation group. Building a practice in will challenges, commercial litigation, shareholder disputes, and unjust enrichment claims. Prior to joining the firm, he worked as an associate at a Bay Street law firm, where he gained experience in commercial defamation and Aboriginal litigation, also involved in drafting information technology and intellectual property agreements. I took note that at one point he was a research assistant to Professor Wadhams in the area of law of damages. I take note of that because he was my perhaps most favorite and influential professor when I was in law school in contracts, and helped clarify my thinking in that area. So I'm sure Brendan and I can both agree on what an expert he is and what he has brought to our own practices. He's been most recently the recipient of the Tory Fellowship Award for publications on economic torts, and we welcome both to what will be a fascinating discussion. Thank you.
Thank you, Anita. And it's probably an example of her tremendous advocacy skills that she could make so much out of such a short bio for me. But thanks very much. Greg and I are going to be speaking about the tort of civil fraud and the remedy of constructive trust. And since it divides so neatly down the center, I'm going to be speaking about the tort liability first, and then Greg will be speaking about the remedy afterwards. So we've already heard about equitable fraud, about fraudulent conveyances, and fraudulent preferences. Those are all very complex subjects. What I'm going to be talking about right now is just the garden variety, nuts and bolts tort of fraud. How do you go about suing somebody for fraud? Now, before I start, I just want to give a simple demonstration that I hope will be illustrative for everybody. Fraud. It has a certain oomph to it as a word. You get this emphasis, this moral indignation with the word fraud that you don't get with negligent misrepresentation or injurious falsehood or some of these other torts. And that's very important actually for us as lawyers, because when clients come in and they say, oh, it was fraud, we have to be very careful, because a lot of people will say fraud for just about any type of dishonesty. They're thinking about that moral indignation. It's also important because if we go around using that word willy-nilly, fraud, there can be severe cost consequences. So what I'm going to be speaking to you about today is the basic breakdown. How do you prove civil fraud? So the paper that Greg and I prepared is at tab 3 of the materials. You'll see that to prove a fraud, there's a 5-part test, and I'll go through it with you right now. First, you have to have a false representation. Second, the representation has to be made knowing that it was false or careless as to whether it was true or false. Third, the defendant has to have intended that the plaintiff rely on that representation. Fourth, there has to be actual reliance. And fifth, you have to have damages. So you're probably saying to me, you know what, Brendan, I can smell fraud a mile away. It has a very specific odor to it. But in fact, each one of these 5 elements is quite technical, and I want to go through each one of them. So first, it has to be a false representation. Now, you'd be surprised, but in fact, there are cases where they get all the way to court, and then the court decides, actually, it was true what he said. So there's one particular case that I like, which is Bradford and Pickles. It's an old English case where the fraudster thought that he was telling a lie when he said, oh, there's no restrictive covenant. Well, they ended up going all the way to court, and the court said, actually, it's true, there is no restrictive covenant. So the whole thing fell apart. So the first thing you should establish is make sure that the statement is false. Now, that can be more difficult than you might think, because some decisions have said that certain statements cannot be either true or false. These are statements about hope or intention. If I say, I hope that the profits are going to go up, or I think I'll sell my shares later this year, those types of statements are statements of intent, not fact. And so the courts have held that just because those plans don't materialize, that's not sufficient to form a basis for fraud. So make sure that it's false. The next thing that you might find a bit surprising is the scope of this word representation. Normally when we talk about fraudulent misrepresentation, we think about something in writing or something that's spoken. But in fact, there's a whole gamut of things that can be covered by this. It's not just what you say or what you write. It can be nodding, pointing, shrugging, anything that you can use to communicate, you can defraud somebody with. And chances are somebody has. In fact, there are some cases, and these probably have to be seen as the outskirts, where the courts have held that even silence can be fraud. There's one interesting case in the materials called Sidlofsky Estate against Baines, where there's a 3-way phone call, and one person, Baines, the defendant, he remains silent on the phone while somebody says, oh yeah, Mr. Baines invested $380,000 into this company. And the other person says, oh really? I think I'll invest. Mr. Baines sits there, doesn't say anything, and by the time he gets up to the court says, just by being silent, he was tacitly participating or accepting that fraud. And so sometimes you can even commit fraud by being silent. Even more amazingly are the cases where you can commit fraud by telling a truth that omits the real truth. There's one case that I particularly like. It's in the materials. It's called, here we go, CRF Holdings and Fundy Chemical. It's a buyer and a seller. They're walking around the property that the buyer might buy, and the buyer says, "Oh, what's that over there?" There's this heap of dirt. And the seller says, "Oh, that will make excellent fill." And in fact, that's perfectly true. It would make excellent fill, but the dirt was actually radioactive. And so the court found that that was sufficiently dishonest so as to constitute a fraud. So you'll sometimes even find cases where it's literally true, but it's sufficiently false to found the fraud. Okay, so enough with the easy stuff. The second element of the tort of fraud is quite difficult. You need to prove that the fraudster made the statement knowing that it was false, without a genuine belief in its truth, or careless as to whether it was true or false. Now this takes us back to the classic case of Darien Peak that gets cited by just about every court, but is probably cited a lot more than it's read. Darien Peak was actually a case about this honest belief issue, and I'll give you some of the background. The defendants in this case operated a tramway company, and they wanted people to invest. And so they told people, we have authorization to run not just horses on the tramway, but steam engines. Huzzah! So people invested in great numbers, and it turns out that the directors were wrong. They didn't lie, they just didn't realize it, but in fact they did not have permission to run steam engines. And so one of the investors, who was named Sir Henry William Peake, a baronet, decided to sue. And it went all the way up to the House of Lords. Now the question was, is it fraud when a person makes a statement thinking that it's true, but having done no due diligence to establish whether it's true or not? And of course, for Baronet Peake, yes, the answer is yes. They didn't do anything. They were careless in making the statement. But when it went up to the House of Lords, the House of Lords said, no, that's not what we mean when we say careless. It's not careless in the sense of you haven't done any due diligence. It's careless in the sense of you're saying it and you don't care whether it's true or false. Maybe it's true, maybe it's false, you don't know, you don't care. You're just making the statement. So in Darien Peake, they weren't liable. This is a very fine distinction, and you can probably find it in the exact same words. My wife and I are in the process of buying a house right now, so I tend to think of everything in that context. But so if I go to a seller and I ask, has the basement ever flooded? And the seller says, no. But the seller actually has never been into the basement, never checked, never did any due diligence. As long as there's an honest belief there, then it's not fraud. Now, if the seller doesn't know whether the basement's flooded or not and says no, that's sufficient to be fraud because he has no honest belief either way. And I hope that doesn't happen when I buy a house. Anyway, the third branch is sometimes the most confusing. It's the intention to deceive. You would think this would be pretty straightforward. You know, did the person intend to deceive? But in fact, sometimes it can get a bit confusing. You see a certain tension in, for example, cases like Gregory and Jolie, which is in the materials. It's at the Court of Appeal. The court struggles with this issue of how is it possible that somebody can be careless in the sense that we've just described with respect to the truth, but then also you have to intend to defraud a person. It's almost like there's these two mens rea elements living side by side. And sometimes that leads to a little bit of confusion, but there have been quite a few cases, even just in the past year, decided on this issue of whether or not there was an intention to defraud. So here's how I like to think about it, that you've got these two different mens rea elements operating at the same time. I'll give another demonstration. I can bench press 250 pounds cold.
Pshaw.
All right. So I have no honest belief that that's true, none whatsoever. At the same time, so I've intentionally said an untruth. At the same time, I don't think that I've deceived any of you good people because, I don't think that anyone actually believed me. I have no intention to deceive, so there's no tort there. Anyways, it can be confusing sometimes to think about carelessness with respect to the truth, but intention with respect to the effect on the people. So you have to keep those two elements separate. So the fourth one is reliance. This one tends to be a bit easier. the statement has to have been relied on by the plaintiff. Now, every now and again, you get a case where the plaintiff comes to court and says, oh, I was defrauded. I bought these shares, and you see this report. It says that the company is going to do all this stuff, and that's all not true. And the court asked, well, when did you buy the shares? And so, oh, many years ago. Well, when did you read the report? Oh, a couple of weeks ago. And the court says, well, no, because you weren't actually persuaded to do anything by this supposed fraud. So that case, by the way, is T&E Ventures and Quadrex Asset Management. It was a case just this year. So you do have to establish that the plaintiff actually relied on the statement. Another way of describing this is sometimes what the courts refer to as mere puff. You know, sometimes you'll make a statement that nobody would rely upon. It's just sort of sales talk. And you see these cases fairly often. There's one case out of BC that I like, again, because I'm about to buy a house. It's called Tunner and Novak, where the plaintiff tried to sue because the defendant said, this would be the perfect place for you to build your dream house. It's the kind of statement that you wouldn't rely on, that it's just sort of sales talk. And the fifth element, the easiest one, is damages. You have to prove that there was some damages flowing from this untruth. So when I told everybody in the room that I could bench press 250 pounds, if you were damaged by that, I'm sorry, I don't think you would be. You probably have a difficult time proving it. So those are the 5 elements. Now, I want to get back now to the initial reason why I posed the question, what is fraud? I mentioned that lawyers have to be careful because proving fraud can be very difficult and there can be severe cost consequences if you fail to do it. So on the first point, I should say this. Traditionally, it was said that fraud has to be proven on a higher standard than the balance of probabilities. It was sort of like this halfway point between the balance of probabilities and beyond a reasonable doubt. And the courts had a bit of difficulty with that because it's difficult to say, you know, what is it, 60%, 75%? You have to prove that it's 80% likely that this person committed fraud. It was a very uncomfortable kind of situation to be in. So in a fairly recent court case at the Supreme Court of Canada, it's C.R. McDougall, and it's in the materials as well. The Supreme Court came out and said, no, there's just one standard. You have to prove fraud on the balance of probabilities. But nevertheless, because of the long history of saying that it's supposed to be higher than the balance of probabilities, you have judges who are going to say that you need to look extra carefully at the evidence. The evidence has to be more persuasive than usual because fraud, like I said with my very first demonstration, it carries this stigma. It's got a certain moral indignation to the word. So the courts are going to look very carefully to see whether the evidence supports a finding of fraud. And the second point that I was making is that if you allege fraud and you fail to prove it, there can be some severe cost consequences. So it's not the kind of word that you want to be flinging about. There are 2 cases in the materials. One is Mealy and Thorne-Riddle. The other is Kamar Rehabilitation. And both of them discuss the fact that if you go and make an allegation of fraud and then you can't prove it because you haven't met one of the 5 elements, then there will be substantial indemnity costs against you. So the upshot is, don't plead the tort of civil fraud unless you're sure that you have sufficient evidence that you can prove all 5 of the elements. 1, false representation. 2, no honest belief. 3, intended to deceive. 4, reliance. And 5, damages. So if you've managed to get through all of that and you've managed to get through my presentation, then you'll reach the stage where you need a remedy. And for that, I'm going to turn it over to Greg.
Thank you, Brendan, and thank you, Anita, for the introduction. My topic is how you can use a finding of fraud to recover an asset, even in the context of a bankruptcy. I've acted for plaintiffs in a large number of fraud cases, and advising victims of fraud is very difficult. The fact is that fraudsters do not usually keep assets on their name. And if you get a judgment against them, they're not likely to take out their checkbook and satisfy the judgment. And then you also have to be concerned about bankruptcy. Is the fraudster, when sued, going to make an assignment in bankruptcy in order to defeat your claims? And as I'll get to in my presentation, you may just find that in that bankruptcy, the secured creditors that you're fighting against are related to the fraudster. Now, this situation is not limited to civil cases. This can arise in estates cases. For example, the estate may be seeking to recover an asset, perhaps the deceased, or the estate was defrauded out of an asset and you're seeking to recover it for the beneficiaries. And that asset might be in the hands of a bankrupt or someone who is going to go bankrupt if you push them. Now, the biggest consideration for the estate, as it is with any client who is the victim of a fraud, is whether they want to risk throwing good money after bad in an attempt to recover the asset. And no one wants to walk away when they have been the victim of a fraud. So there is a base instinct there to go after the person that committed the fraud. But unfortunately, as I've referred to, there are a lot of risks in doing that. And it's essential that you make your client aware of those risks and the difficulty that they may have in pursuing their claims. Now, a lot of your clients will say, can't we get the police involved? And unfortunately, the response is, well, maybe, but probably not. The fraud squad is inundated with fraud claims. And you might be able to get their interest. They do show interest in very significant frauds in the millions of dollars or frauds that have impacted a large number of people. But you don't have, as a civil lawyer, any control over what the police are going to do or whether the Crown will actually press charges. So you're left offering the services and only the services that you can provide, which is to sue the person. And in suing the person, especially in a fraud case, your focus has to be on whether you can recover. And that brings me to the main purpose of my presentation, which is to discuss constructive trusts and how you can use that remedy to give you an upper hand in a fraud case. Now, the principles of constructive trust are well known to most estate litigators, but one context in which it might not be well known is that it is available to remedy a fraud. The typical claim for constructive trust, at least in estate litigation and in other litigation, is based on unjust enrichment. And you're likely familiar with the elements: enrichment, deprivation, and a lack of juristic reason. But sometimes, in fraud cases, the unjust enrichment framework just doesn't quite fit. Establishing an enrichment and a deprivation is always the easy part. But whether there is a lack of juristic reason might not be clear-cut. For example, you might have a contract between the fraudster and the victim. They might be a financial advisor who has performed some legitimate services but also has committed fraud. That muddies the water. But in the case of fraud, you can bypass that unjust enrichment framework and go straight to the remedy. And there's an often cited case called Soulos and Korkanzelos, where Justice McLaughlin stated, "I conclude that in Canada, under the broad umbrella of good conscience, constructive trusts are recognized both for wrongful acts like fraud and breach of duty of loyalty, as well as to remedy unjust enrichment and corresponding deprivation. So a constructive trust is available as a remedy even when you do not necessarily prove unjust enrichment. If you can prove your wrongful act, if you can prove that fraud, then it opens the door for the constructive trust. But there are, of course, significant hurdles. Proving the fraud is the first hurdle, and Brendan has addressed the law on that. The next hurdle is establishing that a constructive trust is the appropriate remedy. With respect to claims of fraud, the ordinary remedy is damages. You get a judgment saying that your fraudster has to pay you a certain amount of money as compensation for your loss. But a judgment for damages does not give you any priority over other creditors. And in the event of a bankruptcy, a judgment simply makes you one more unsecured creditors, possibly among many. And it leaves you subject to the priority claims of secured creditors. So the judgment itself for damages is not enough. You need more. You want more. Now, the only way to effectively obtain a priority for your client to recover the asset that was the subject of the fraud is to obtain a proprietary remedy. It's to say that specific asset that was the subject of the fraud, I or my client has a property interest in that asset. And constructive trust is the way to do that, but simply saying constructive trust is available for fraud, unfortunately, does not get you the remedy. The court must exercise its discretion to award that proprietary remedy. Now, in the context of a bankruptcy, a constructive trust imposed on an asset of the bankrupt estate actually has the effect of removing that asset from the property of the bankrupt. And it's Section 67(1)A of the Bankruptcy and Insolvency Act that expressly excludes property held in trust for another from the property of a bankrupt that is divisible among the creditors. And trust assets have been interpreted by the courts to include assets that are the subject of a constructive trust. So that means that if you are successful in obtaining the constructive trust over an asset, you will be reducing the pool of assets that are available to other creditors. So right off the bat, that pits your client's interests against those of other creditors. Now the question becomes, why should one creditor gain a super priority over secured creditors and unsecured creditors who are also owed money? Creditors who might be innocent, no connection to the fraudster at all. And the reason basically comes down to this. Someone who willingly, for example, loans money to a person, they can take steps to protect themselves. They can take steps to get security. They go in with their eyes open. The victim of a fraud often does not have that ability, and that is the essential moral basis for saying a victim of a fraud should get a priority. But the courts have held that a constructive trust will not be awarded just for the sake of giving you that priority. It's more complicated than that. Rather, the court is going to look at all of the equities and the impact that the imposition of a constructive trust will have on other creditors before making the decision to remove that asset from the bankrupt estate. And in addressing the equities, the starting point is a case called Green Street Management, which is very often cited in bankruptcy cases where there is a fight over assets. And it stands for the principle that a trustee in bankruptcy has a duty as an officer of the court to act in an equitable manner to all parties. So what does that mean? It means that as counsel, you have to convince the court that justice favors your client exclusively recovering the asset. Now, being the victim of a fraud gets you a good part of the way there. A more recent decision of the Court of Appeal addressed what the court will consider in deciding whether to go the rest of the way. And that case is the Credit Finance Securities decision, which is a case that I was involved in. I acted for a company called DSLC, and it had been defrauded out of hundreds of thousands of dollars by Credit Finance. Now, when DSLC was successful in obtaining an order freezing what remained of those hundreds of thousands of dollars, Credit Finance made an assignment in bankruptcy. They knew what they were doing. It turned out, of course, that the secured creditors of Credit Finance happened to be the principal of the bankrupt company, his related companies, and his agents. So the individual who perpetrated the fraud coincidentally had positioned himself to swoop in and rely on the Bankruptcy and Insolvency Act to scoop all of the remaining assets. Now, to avoid that result, the only real option for DSLC was to try and pursue a proprietary remedy, to try and say that the assets that are remaining in that bankrupt's bank accounts are the proceeds of the hundreds of thousands of dollars that DSLC had been defrauded out of. Now, I deal with the procedure for making that sort of claim under the Bankruptcy and Insolvency Act in the paper, but I don't plan to get into it in any detail in my presentation. But I will start off by saying that the claim is made to the trustee in bankruptcy. Now, that itself presents some problems. Now, although the trustee in bankruptcy is recognized as an officer of the court, the fact is that it is usually the bankrupt or the principals of the bankrupt that choose their trustee, often pay their trustee, and it may be those secured creditors with a tie to your bankrupt that are even instructing the trustee as inspectors of the estate. So, in any event, in the DSLC case, the claim was put to the trustee in bankruptcy, and the trustee disputed it. That means, in bankruptcy speak, that they denied the claim. Now, that led to what is referred to as an appeal to the court. And in that case, it was to a judge of the commercial list, but it could have just as easily been to a registrar in bankruptcy. Both have the power to determine those types of appeals. And what happens depends on what agreements you make with the trustee. It also depends on what you can convince the court is the just way to proceed. But in the case of trying to prove fraud, what you really need is a trial. And as a result, in an appeal where you're trying to establish fraud, you will usually require a trial de novo to go back and attack the trustee's decision. And the starting place for attacking that decision is to prove fraud. So in the DSLC case, there was that trial of an issue. Witnesses were called, arguments were made about whether there was a fraud, and if so, what the appropriate remedy should be. And the trial judge, in fact, the referred to as an appeal judge, did find fraud, awarded the constructive trust, and took that asset out of the bankrupt estate and gave it to the client. That was appealed to the Court of Appeal. And in the Court of Appeal, the trustee was arguing that DSLC had no proprietary claim and that it should be treated like a regular unsecured creditor. Now, including the fact that the secured creditors waiting in the wings included the fraudster and his agents, that was an important consideration for both courts. Now, with that in mind, the Court of Appeal determined that it would be, quote, fundamentally unjust to deprive DSLC of its proprietary interest in the remaining assets. But a central issue that the Court of Appeal was concerned with was whether the imposition of a constructive trust would open the floodgates in bankruptcy cases to creditors seeking super priorities. Now, ultimately, the court was satisfied that in the circumstances of the case, the finding of fraud and the imposition of a constructive trust was appropriate. But the Court of Appeal went on to state, before leaving this issue, I believe it is important to make a final observation. The appeal judge's reasons should not be interpreted to suggest that once a civil fraud by the bankrupt on the claimant, whose claim was disallowed by the trustee, is proven, and that is coupled with a loss and an ability to trace the consequences of the fraud, then a constructive trust will always be imposed. That, in my view, is too broad. Constructive trust is a discretionary remedy. In a bankruptcy, there are other interests to consider besides those of the defrauder and the defraudee. There are other creditors. Thus, the exercise of remedial discretion must be informed by additional considerations than in a civil fraud trial. The appeal judge in our case clearly understood this, considered the claims of the creditors, found them to be tainted by the wrongdoer's misconduct, and concluded that a rigid, formulaic approach relying on the Bankruptcy and Insolvency Act would produce an unjust result. So what do we take away from this case? Whether you can succeed in obtaining a proprietary remedy within a bankruptcy will depend on the circumstances of the case and the competing equities. But being able to prove fraud is not enough. You have to convince the court that it is appropriate to remedy that constructive trust. There are other issues that are dealt with in the paper, such as the tracing of the asset. If you cannot connect a specific asset in the hands of the bankrupt fraudster to your claim, you're likely out of luck. Similarly, if you're trying to trace your money into a commingled account, you're going to have a lot of difficulty as well. But those issues are dealt with in more detail in the paper, as is the actual procedure for bringing this type of claim. But in conclusion, what I would say is, for a victim of a fraud trying to recover assets and trying to give themselves the best opportunity to do that is very difficult, it's very involved, and it can be very expensive. Your client has to know that going in so that they can make an informed decision. But it can also succeed. There are a number of hurdles that you have to get past in pursuing such a claim, not the least of which is proving fraud. But in the right circumstances and with the right facts, this pursuit can successfully recover the asset that your client has been defrauded of. Subject to any questions, those are my comments.
Are there any questions?
Thank you.
I just have one question I wanted to follow up on something that Greg was saying. You gave a lot of warnings to the litigators in the room, I think, about the extent of this decision. What is the threshold, do you think, on a fraud case? How is it best to measure whether or not the case that you did before the Court of Appeal has application for the potential? Is it just that the ne'er-do-wells have to be the secured creditors? Is that the dividing line?
It's impossible to refer to any specific dividing line. All of the facts are going to be different. But the most important thing is, before you go down that road, to really consider the assets and the likely assets of your defendant and what you think you can prove, what you think you can accomplish if that individual has no assets on their name by the end of the day, or if they do declare bankruptcy. So, this is one of those cases where you're going to have to use your skills to argue, the justice of the case and try to get the remedy for your client.
Thank you.